Hi there, and welcome to sydneydrinkdriving.com.au. Hi guys, Josh Borman here from sydneydrinkdriving.com.au. Just a quick update on a matter I had at Parramatta Local Court about a week and a half ago. My client was charged with a Middle Range PCA offence. His blood alcohol reading was 0.116. Now, the reason why this matter was more serious than just a normal Middle Range PCA offence is the fact that only 3 years ago he was also charged with a Low Range PCA offence. So he was considered a repeat offender, and certainly a second or subsequent major traffic offence within a 5-year period is dealt with far more seriously by the courts. On this occasion, basically I was able to express to the magistrate that there were some extenuating reasons why my client found himself to be behind the wheel of a car after consuming the alcohol that he did. And basically it was that he had gone to lunch that day with his wife and his daughter. They'd had a barbecue at a friend's place. His wife wasn't drinking, she drove that day, they went home. That night, he and his wife ended up getting into quite a heated verbal argument. She took off with their daughter, and he was left at home to basically stew over the emotional fight that they had had earlier in the evening. He continued to drink whilst at home and then made a very foolish decision, and I would say, and I did submit to the court, it was a very emotionally driven decision to get into his car late at night and go and look for some food. Now, there were no aggravating features surrounding this incident. He was the sole occupant of the vehicle, pulled over for the purpose of a random breath test. He wasn't speeding, he wasn't driving erratically, there were no other charges involved. He was polite, he was cooperative with police, and certainly the risk to other people on the road was reduced given the time of night, that there was hardly any traffic on the road late that night. So basically these issues were taken into account by the court and shown that it was a more standard type of PCA offence rather than something that involved a collision or death or injury to other people, or even a risk of death or injury to other people. I was able to explain to the court that my client had a very real need for a driver's licence. He needs to operate heavy machinery and needs to have a driver's licence in order to perform his work. Obviously he's married, he has a child, he needs to provide for his family. He is the sole breadwinner for that family. Without a licence, it is going to be extremely hard for him to get by. Now, being a repeat offender, he had to expect that he was going to spend some time off the road. He was certainly hoping to get a reduced period of disqualification so he could get back on with earning a living and providing for his family. I was able to persuade the magistrate that there were a number of subjective features about my client, the way the incident came about, what he does for work, and his real need to be able to maintain a driver's licence for his work. I was able to push these points across to the magistrate and persuade the magistrate out at Parramatta to reduce his period of disqualification down to the 12-month mark. He'd already been off the road for a couple of months when we went to the final court hearing, and this period of suspension was taken into consideration in relation to time already served with the 12 months disqualification that was handed down by the magistrate. He was given an $800 fine, he was convicted, there was no good behaviour bond, and there was no community service. So despite the fact he was a repeat offender, we were able to get just the minimum disqualification, a reduced fine, and we were able to get his disqualification period backdated. The other important thing that we were able to do was get an order for an alcohol interlock device put in place. Now, it's unsure whether my client will exercise the option to get an alcohol interlock device put into a vehicle, because he does operate heavy vehicles and machinery around the work site, and this may not be suitable to put an alcohol interlock device in. However, if he wants to get back on the road driving his normal work ute and vehicle, this is an option that he may be able to exercise. Once he has completed the initial 6 months disqualification period, he would then have to have the device in his car for 2 years, but in saying that, he would be able to continue driving a normal vehicle as long as it had this alcohol interlock device in his car. He was extremely happy with this outcome. He was looking at least 18 months disqualification or even higher, and a fine of around $1,500 to $2,000, but we were able to dramatically reduce both of those sentences down for him, so he will be able to get back on with earning a living and providing for his family a lot quicker. Certainly, he displayed a true sense of remorse to the court. We were able to help him put together a statement which he tendered to the court just to show what he had learned out of taking part in the traffic offenders program, and the real emotional types of presentations and lessons that he took away from that program. And this was certainly very well responded by the magistrate, who actually turned around and said, well, it looks like that your client has finally got the message. And I think it was quite well taken and understood that this will be the last time my client will appear back before the court on such a charge as this one. Guys, if you have been charged with any sort of alcohol-related traffic offence or drink driving matter, please feel free to give us a call at our office on 02 9283 8622. You can have a chat with me. I'm happy to have a free first telephone consultation with you just to explain your charges, the situation you're in, and what can be expected when go to court. And if you need to get us on board for professional legal representation, rest assured we are extremely experienced in these types of matters. We do lots of them every single week at various different courts in and around Sydney. So we're very capable at handling these types of matters. We also represent these types of matters on a fixed fee basis, so there's no extra or additional costs involved after we've provided you with that initial quote. Alternatively, jump onto our website if you haven't seen it. It's sydneydrinkdriving.com.au. There's plenty of information there surrounding laws, penalties, and various other issues about drink driving and alcohol-related offences in New South Wales. That might be your first starting point to familiarise yourself with a bit of information surrounding these types of criminal offences, but certainly give us a call, 02 9283 8622, and I'm happy to have a chat with you about your situation. Thanks, guys.